living will is a legal document which gives medical treatment preferences along with judicial precedents also, or what?
See, there are 3 judgments which has made this jurisprudence so far. And last month, there are guidelines issued by the Ministry of Health and Family Welfare. So, it is an evolving jurisprudence. It has yet to evolve.
You have made so much notes, I'm just seeing.
Yes, because we have to deal with the 3 judgments and
we are starting.
Okay.
Good evening, friends. Amongst us, we have Justice Roshan Dalvi, who is on a lot of sessions, and the most fascinating part is that we think that it is a challenging topic, but she accepts it and then she puts it with such an ease. That is the art of a good communicator, good person who can make you understand things. Now, before going live to the session, we were discussing with her as to how the concept of living will has evolved and how the legal journey with respect of the latest judgments have also given us the guidelines in respect of person's choice of medical treatment, etc. As to how who would like to undergo his medical treatments in respect of life-sustaining treatments, pain magnetism, artificial nutrition, then all these cares, etc. We are too happy that after she was away from India for around 40 days, and the moment she came back, we asked her and she readily accepted it. Being a marriage season, we will not take much time. I will request ma'am to take over the session. Over to you, ma'am.
Okay. Good evening, Vikas, and good evening, friends. This is an evolving jurisprudence. We have come a long way from Section 309 of the Indian Penal Code, which dealt with suicide as an offense. So when it was not a successful suicide, the person could land in jail. There was at that time a lot of clamor about the right to life and who can take it and who cannot, the dignity of life and the right to end that life. And Section 306 also came into play at that time for abetment. Now we are ahead of all that. There are certain organizations which work for people who want to commit suicide. Those may be youngsters, they may be old persons, whatever way. There is one organization which has won an award, an international award as the best organization dealing with the right to life. But friends, we have come to realize from the various ailments that we now suffer, which are called rich men's diseases, like diabetes, like cancer, etc., that you come to a stage which is terminal. And then there is no hope. But life goes on, the person suffers, the caregivers suffer, and therefore the question of euthanasia becomes important to consider. Now, there are 2 types of euthanasia, active and passive, which our judge-made law has made clear. Active is actually injecting something into a person to end life, which the person is suffering from. Passive is removal of or withdrawal of life support systems. Okay. Now, in 2011, the first of such cases of euthanasia actually became popular. That was the case of Aruna Shanbag versus Union of India, in which Pinky Virani, who had written a book on Aruna Shanbag, made an application by way of a writ petition to the court to end her life. Because at that time, she was suffering in bed for 38 years with absolutely no hope of recovery. Now, this was a very unique case. She was molested, tied up, brutally assaulted, and left chained and left by one person who got some 7 years imprisonment and then he was set free. But Aruna was not free. And therefore, books have been written on her, articles have been written on her. She was in KEM Hospital, Mumbai. That is King Edward Memorial Hospital, Mumbai, which is now a municipal hospital or a government hospital. There, the nurses cared for her. And today, it is about 5 decades that she has been cared for. We were told that the last dean who came there as a dean came to take her blessings while she was on, we can say, deathbed. But in that case of 2011, Aruna Shanbag, Justice Kazu's judgment set out the euthanasia jurisprudence of various countries and then considered it alongside ours. When we are considering the living will or euthanasia, please always remember that at least in our country, I can talk about our country, it may be in other countries also, there is a lot of abuse of laws. All welfare legislations are abused. And therefore, courts bear in mind very clearly that that abuse cannot be used in such cases. If a person herself or himself decides that he would not want this life support system, or that when he becomes terminally ill, at present it is only when he is terminally ill, he can allow himself to live a life of dignity and die in peace, it would be a step forward. But in the case of Aruna Shanbag, there is a mention of living will in paragraph 24. Mr. T.R. Andhyarjuna was appointed amicus and he assisted the court very ably, and there was one doctor's report which was considered. Now, passive euthanasia and active euthanasia were also considered. Passive euthanasia, upon doctor's advice, and if accepted, consented by the patient or the patient's caregivers, could be allowed. It was not an offense, it was held, and therefore there was no problem. In paragraph 40, there is a clear observation that when the patient consents, then there will be no legal difficulty, which is a great step forward. But the right of doctors to decide, it is held that it is the right of doctors to decide, not only the patient. The doctor must understand and opine that yes, it is a terminal illness. It's not that any patient can just end his life. It is not also for the court to decide. It is held that the court only cannot advise, but the court only gives a declaration that the act is not unlawful if you go to court. Having said that, and having considered the various jurisprudence of various countries, it was held in that case that Aruna Shanbag's life could not be terminated. She was breathing herself. She was not on a heart-lung machine or a ventilator or whatever. And they made a distinction between brain-dead person and brain stem-dead person. So when you are only brain-dead, the stem is effective. The person makes some kinds of signals. Therefore, there is circulation and there is some life into that patient, which the patient may not be able to convey. Under Section 2D of the Human Organs Act 1994, which was considered in that judgment, what is brain stem death is laid out. And that is that all functions of the brain have permanently and irreversibly ceased and is so certified by the doctor. So when Aruna breathed on her own, it was held that her brains, she was not in a brain stem death situation. She was living, she was eating, She was given a liquid diet. She liked certain particular foods and showed her happiness for that, and therefore her life could not be terminated. Now, this withdrawal of support, which she may have had, some kind of support was always there. Who can withdraw was laid down. Pinky Virani, who wrote her book and who was not a caregiver of Aruna, was held not to be a competent person to decide or to give her consent. It is only the relatives, the next of kin, or the caregivers who would do that. In that case, the nurses and the doctors of KEM Hospital were the caregivers. So the court held that they don't want her to die. Pinky Virani wants her to die and die with dignity. So, despite lauding the various things that Pinky Virani had done as an activist, withdrawal of support was not allowed. It was held that it could be by relatives and in the best interest of the patient. KEM, the court held, with the court approval, can at any time withdraw support. But they will have to take court approval. Now the matter rested for another some years until the petition 215 of 2005 came to be filed, Common Cause versus Union of India. And in that, the right to life, the right to end life, and the right to live with dignity was considered in the question of euthanasia. Now the court, it was a 3-judge judgment, and Justice Deepak Mishra, writing for Justice Kanvilkar also, and Justice Ashok Ban separately, considered the question of euthanasia and laid down various guidelines about how euthanasia could be accepted. It turned out to be quite unenforceable, and that is not the fault of the court. The court considers upon its own experience that these things can be misused or abused, and therefore the greatest care had to be taken. While taking that greatest care, it so transpired and people felt that nobody can really make a living will and get it executed at the time it really wants if all those provisions would have to be followed. And therefore, for that 1% of the cases which could be fraud, 99% of the cases would have to suffer. So, there was an application made. And that application was made, friends, by an organization called Indian Society of Critical Care Medicine. As an applicant, they applied, and it was before a 5-judge bench. Justice Justice K.M. Joseph at that time gave guidelines by making the earlier guidelines a little more streamlined and a little more relaxed. We have therefore to see those guidelines today. Now, under those guidelines, the living will is called Advanced Medical Directions or Directives. So, a person can, in advance, give directives for medical purposes about what you should do with him or her when she is not or he is not capable of doing that because he or she is temporarily or rather terminally ill. Now, these advanced medical directives can be expected naturally of an adult person of sound mind, voluntarily given, without coercion, duress, undue influence, etc. And there is an implied consent in that it is without undue influence. It should be in writing. It should be executed by that person when the medical treatment may be withdrawn for her or him, and when no medical treatment shall be given to her or him, which would delay his death or cause pain, anguish, etc. Now, this has to be attested by two independent witnesses. Independent witnesses, I would say, could not be the next of kin. They would be some friends or outsiders who would attest that the person was in a sound state of mind, that the person voluntarily did this, this is what he did, and that he has spoken about it. So they certify that. That will, living will, would have to be then notarized. The notary would also have to certify, which is very fine. The notary would certify that the person has voluntarily made this will for what would be the medical directives that he or she would want in advance. The important thing is that it should mention, of course, it would go without saying, I would say, but it should mention that the executor may revoke these instructions or authority at any time. And a will is always revocable, living or otherwise. The most, if suppose there are many living wills, like he has revoked the authority, he again gives authority because he reconsiders, then in that case, those cases would be very few. The most recent of the directives would be followed. Okay. Now, all this is very fine. A copy of this will have to be given to the family physician. That's also okay. Copies of this would have to be given to the concerned persons who would then have to consent on behalf of that person when he is incapable of consenting. So his close relatives would be given this will. As a matter of fact, it would be that the will should be executed in triplicate or quadruplet. Everyone should sign and everyone should mention about whatever is the voluntariness to make it more effective. So far, so good. But the court must have thought that this may lead to some abuse of some person, by some persons of some others. And somebody could be forced to make a living will, or that the consent could be given by anyone very freely, which quite often is actually done. But the court said that the copy would be given to the municipal authority. Now, let us take, for example, in a metropolis like Mumbai, where the BMC, the Bombay Municipal Corporation, is the municipal authority, a huge undertaking where there are various departments and wards. And who would know about this living will? Because there are not so many living wills made. The BMC would have to appoint, or whichever authority would have to appoint a competent officer nominated by that municipal council who shall be the custodian of that living will. So one copy would be with him. These officers would be transferable. When the transfers take place and each officer has got various assignments like we judges have, we would not know what would happen to the living will. But there is a ray of hope, and with today's computerization, there could be a digital health record of the municipal corporation or council. And this living will could be entered into the digital records. If that is done, then technology would allow this kind of will to be used when it is most required very urgently. After all this, there is a requirement for a primary medical board. So a medical board would have to be constituted. They would have to understand from the physician what is the position of the patient, and they would accept, allow or disallow life support to be withdrawn or not with the consent of the kith and kin. And this decision would be then placed before a secondary medical council. If that is also not allowed, then you have to file a writ petition, which comes up before a division bench. And in every single of the 25 courts of our country, they are packed to capacity with work. So we don't know when that would reach. And they would have to inform that decision to the JMFC. Now, the JMFC is also a transferable post, and we don't know which JMFC would be the right JMFC to be given or informed that decision. If suppose the permission is refused by the doctors, because the doctors feel that that patient is not terminally ill and can be saved, then also a writ petition could be filed before the division bench, and the bench would consider, which generally happens that the bench takes the medical opinion only because the bench is incapable of otherwise deciding. Anyway, this is when advanced medical directions are given so that a living will is made. What if a living will is not made? Not many make wills altogether, but this is a living will, which is a separate thing as of now. The cases of no advance directives, that is no living will, the same practice have to be followed of the primary medical board, the secondary medical board, etc. Now, this comes up before the medical board by itself when the physician or the kith and kin would say that he is terminally ill and let us withdraw the support because there is no point continuing his life. So there will have to be a meeting of the physicians. They would have to write the minutes of the meeting and the discussion. Those would have to be then given to the secondary medical board. If that is not allowed, again a writ petition. And after the writ petition is filed, if support is allowed to be withdrawn and is withdrawn, then notice to the High Court. These are so far the easiest of directives. But friends, while we are discussing, we are all in the pink of health. And if we feel that 10, 20 years from now, we don't want to go through that situation or make our relatives go through that situation, we make a living will. And we say that, please, at any time, when I suffer from this, that, and the other, I do not want medical treatment. And if medical treatment is given and I don't understand, please withdraw that medical treatment. And this is the will, and you've registered it and you've done all those 4, 5 things. Will at that time, because of these directives, which are meant for the safety of these old persons, be effective? That is a moot question. But once a living will is made by a person like you or me and is registered and is shown, it would show that these are the real advanced medical directives of that person of his voluntary will. Now, after these directions came, one of our finest judges, Justice Sonak in the Bombay High Court, he's still a sitting judge, he made a living will. Can anyone challenge that living will? He is a sitting judge. So just as, friends, we would consider the effectiveness of a will, which is otherwise made for property, it could be made for the person also. And sooner or later, people would make a living will as one paragraph in his or her will. By now also, there are paragraphs in the will relating to funeral expenses, obsequial ceremonies, etc. How much to spend, how much not to spend. Aside from that, they can talk about before the funeral what should happen, and then also talk about their properties and bequeath the properties as they wish. This, so far as the properties are concerned, would be challenged as usual, as is done by now, because the relatives would want, if they are not given the properties under the will and if they've not got any bequest. But the question of living will in such a case would be more settled because a person has made this. Now, a will today, which is made, has to be attested by 2 independent witnesses who will attest in the presence of the testator and then report that the testator was in a sound state of mind. At times, even the doctor is called when the testator is old to opine whether or not he is in the sound state of mind, and the doctor gives an endorsement. And wills may or may not be registered. It is not a compulsorily registrable document. Even a living will talks nothing about registration of the will. If it is in the registrar's office, then there are various conveyances, gifts, and mortgages which are compulsorily registrable all there. And therefore, the court has, I think, very wisely kept the living will aside from all of those and separately with the municipal authority. So, municipal authority will have only living wills. And if there is a digital record, the digital health record of the municipal corporation, which now would be coming into play, then it could be extracted very easily and it could be forwarded also to the physician, to the primary medical center, medical board, secondary medical board, and the high court. So that would be a silver lining. It is a new horizon. Talking about the living will, the government also seems to be working upon it. And last month, there have been certain directives of the Ministry of Health and Family Welfare. They have released a draft guidelines for the withdrawal of support, and key mechanisms have been laid down. So, as I said, this is an evolving jurisprudence. A lot can be done. There may be cases of abuse, and we would be older and wiser at that time. Now, I would like to add a rider. When a person makes a living will and he understands that he is going to be terminally ill, suppose his brain stem dead at a given time, but the heart functions, all the organs can be donated and they can be transplanted into various other persons. I know about one of my friends who is a lawyer also. Her daughter was in that state. While her daughter was in the coma, as we generally call it, she gave away her organs to 7 individuals. It is a courage of a mother to do such a thing. But she said that my daughter lives in those 7 individuals. So these are the things that could be done. And if somebody makes a living will, they may consider donation of their organs. Now, for every person who is dead, eyes and skin can be donated. Eyes, of course, would give sight to so many people if, fortunately, people donate eyes. Skin in our country would be very, very useful because we still have cases of acid throwing and we have cases of homicide in homes where kerosene is thrown on a bride, match is lit, and she dies in flames and she dies of septicemia. So, if those organs, at least those 2 organs are given, a lot can be done. But the persons who have those organs which have been transplanted into them, like the heart and the liver, even a part of the liver can be transplanted. Heart can be transplanted. I know of a young girl who has got a heart, and somebody must have given it that way. So I would say in the living will, even that provision can be made, and then what you have to do of your body later for medical research or cremation or burial or whatever. That could be a rider to this, and perhaps this also could be settled when we settle the question of living will. I may tell you that in England, under the Children's Act, under Section 8 of the Family Reform Act 1969, and thereafter the Medical Capacity Act 2005, it doesn't deal with the living will, but it deals with what doctors and the patient's relatives can do in certain circumstances. Now, there was a contrary case earlier where some of the Jehovah's Witnesses, it's a community which believes that God gives us life and therefore only God can take back the life and we should not tamper with it. There was a 16-year-old boy who had leukemia and he had to be given blood transplants. The parents were against it They said this is not what the Lord has ordained, and therefore it cannot be done. So the doctor brought the matter to court. He was a 16-year-old boy, so he was a child until he turned 18. And therefore, under the Children's Act, the court which dealt with that legislation dealt with it. And the lady judge considered the case of the boy who wanted to live and who wanted to get the blood transplant. The parents, who you cannot say they did not want him to live, but they wanted him to live only naturally and not by this kind of injections. And the Human Rights Act in UK, which is much like ours, that we do not take anybody's life. We have to tell our utmost to save life, to lengthen life, no matter whether it has dignity or not. And that was called the case of Gillick competence. Because the 16-year-old boy, the court held, was in a sound state of mind and capable of understanding that he wants to live. And therefore the court ordered that this transplantation of blood must be done, much against the parents' wishes. It was done, but it was always not a permanent solution. Therefore, it was wanted again. The boy did live a very good life for some time, and again he was back. And I think later the boy himself decided that enough is enough. So, friends, today we have to go up to that position. Long years ago, in Kerala, there was a petition I had read in the paper that a man said that he has had a full life. He is now 80, 85 years old. He's got grandchildren, great-grandchildren and children, all are well settled. He doesn't want to live and particularly be terminally ill and then die. So he filed a writ petition that he can terminate his life, which was dismissed. At that time, the concept of living will was not there. But I remember reading a Reader's Digest article at least 4 or 5 decades ago, which talked about this kind of passive euthanasia, and even I would say some kind of active euthanasia in various countries. And 2 of the examples that I have not forgotten are one in Belgium, where it was a small nursing home or a hospital, and the doctor needed a bed. The beds were not available. And in one of the beds, a very old person, completely terminally ill, was just on life support system and going on. And a young person who could be treated and who could have a very good life thereafter could not get the bed. So the doctor insisted that the life support be withdrawn. He wants the bed. I remember that story. The second was that in some countries, doctors give pills. They tell the relatives that, see, you give only this much, because if you give more, he will die immediately. And they know that this man is not really capable of or worth living with dignity. And the doctors say that we tell this, we give the bottle to the relatives, and we go away. And by the time we have turned the street corner, we know that the relatives have given him several pills. The next day, he is no more. So that was the situation. And now the situation is really on the right to life, the final right to life that a person can have. So, friends, we would have to keep tabs upon what the government does and what the court does, and accordingly make our living wills. Thank you.
Thank you, ma'am. I'm just checking out the chat. There's only one question, but that is out of syllabus of the session. It is whether cause of action runs concurrently in a partition suit.
Pardon? Better?
No, that's a question out. I will say just like we study out of syllabus, whether in respect of partition suit. Since it's a new subject, I think there will be only brownie points to be taken. And thank you, ma'am, for sharing your knowledge. And do stay connected with us tomorrow on passion and purpose of life with Sai Chandra. Thank you, everyone. Stay safe, stay best. Namaskar.